Huntington, in this sense. You simply have completed your work as a receiver, and you'd like to close down the receivership and simply
Move on.
move on.
That is correct, Your Honor. We feel we've completed our duty as the receiver. We're ready to move on.
All right, and so your request here is simply that I approve the sale of assets.
That's correct.
All right, I got it. That's easy enough, Mr. Van Helton. Thank you very much.
I would also state, since the court did request, to the extent responses to various filings present for argument today need to be made, there is comment made in filing to intervene regarding the receiver and his exercising of the duties under the May 15th order. If there is going to be time allotted for response, we would appreciate that.
Yes, and I'll give you time, Mr. Van Helton. All right, thank you. And so I assume that you're essentially sitting this one out now, except you want to respond as a matter of law to the arguments that may be made, and more importantly, I need to know as a matter of fact what happened.
Yes, we're on the bench now, Judge. Not yours, but the
Right,
bench.
I got you. I understand. Thank you very much. Okay, now, Mr. Brunda, you represent 14 Corporation, right?
Yes, Your Honor.
Now, you are the creditor in this, and as I understand it, your position is that you are satisfied with the manner in which the assets are proposed to be disposed of, and you simply want the court to enter some sort of order ratifying the sale of assets, and then you can realize whatever gain you might get from the sale of those assets, and then as a creditor, you're finished as well. Is that correct?
Yes, Your Honor.
All right, that's fair enough. Now, let's talk to some of the other people, because this is where it gets more complicated. Mr. Turing, as I understand your position, you were the successful bidder in the view of the receiver here, and you simply would join in the receiver's motion to approve the sale of assets. Is that correct?
That's correct, Your Honor.
Fairly straightforward argument.
That's correct.
Okay, fair enough. Now, Mr. Ornstrom, tell me what it is that you want me to do, because I've done a lot of work trying to figure out exactly what the powers of a receiver are and what my powers are here. And I'll tell you this is, I think, where I come down here. It's not my prerogative or my obligation to make some sort of normative judgment here about how the assets should be disposed. Nor is it my right to supplant the role of the FCC by making a determination based upon the local radio market of who should have the license. The FCC plays that. However, although I can't get involved in what I might describe as a substantive process approach, and I know this isn't a constitutional claim, there's still this matter of procedural fairness or procedural propriety, and since the assets are technically in the hands of the court, it's my obligation to determine that the sale of assets is just and proper under the circumstances, right?
That is correct.
All right. Let me ask you a couple more questions, because and then I'll let you say whatever you want to say. I'm trying to get my arms around this. There are a couple of other things that I can do under the statute as I see. MCL 600.2926 is the statute which defines the power of the court to appoint a receiver and to terminate a receiver. One of the things that statute says is the court may terminate any receivership and return the property held by the receiver to the debtor whenever it appears to be in the best interest of the debtor, the creditors, and others interested. Now, you're not asking me to do that, to return it to the debtor.
We are not.
Right, because there's been some suggestion here that this purchasing consortium might include the debtor, but that's not the case, right?
It is the case.
It is?
It could, because there's a issue of some real property. There's an issue of redemption of the real property that's in a mortgage foreclosure. So that's kind of a side issue, but it exists.
Let me talk to you about redemption, because it hasn't been formally brought up in the papers, and so I'm going to have to hear from everybody on this, but I need to understand what the theory of redemption is, because redemption would mean essentially that the assets would go back to Mr. St. Cyr. Is that correct?
Okay.
Well, not all of the assets, as I understand it, only the real property assets, because I think the foreclosure only covers the real property.
So when you talk about the real property, you're talking about the property at
Eastern Avenue, correct?
1919 Eastern, right?
Correct, Your Honor.
Okay. All right, I understand that much. So, at least in theory, you'd like me to consider the authority of the court to terminate the receivership and return the property to the debtor. I'm not saying I'm going to do that.
I understand that, but it is certainly a consideration for the court to give. It's not my primary argument, but it is certainly something the court has to consider.
All right, talk to me about redemption now before we get to this disposition of assets. On what basis do you claim a right of redemption?
Well, it is, you're right, it's probably not my client currently that has the right of redemption, although
Right.
my client has communications with Mr. St. Cyr, and he may have an agreement with Mr. St. Cyr that they would fund the redemption. So,
But I'm confused by that because you don't represent Mr. St. Cyr.
that is
right?
correct, I do not.
All right, so at least insofar as your authority is concerned here, you represent a bidding consortium, but not the debtor.
That is correct.
So if Mr. St. Cyr's attorney were to appear, I could, in theory, consider the last paragraph, but you can't really ask me for that on behalf of your clients because your clients don't have a right of redemption. Mr. St. Cyr may.
To my knowledge, and I don't know this, whether there's been an assignment of that right of redemption.
Right, because that would affect the authority of your clients to seek the relief, the right of redemption. I'm not saying that there's any right there, but I don't even understand fully how that works out yet.
Right. And that would, I think we are a little bit short because it's my understanding that there is an agreement. I haven't seen it in writing. I cannot represent to the court that we have authority to redeem the property on behalf of Mr. St. Cyr, nor do we represent him.
All right, I just want to be clear about that because I want to understand all the remedies that are potentially in play here and all the arguments that are in play. Leaving that aside, we take redemption off the table. I'm not saying we have to, but you can't really argue for it right now.
That's correct.
If we take redemption off the table, tell me what the legal basis is for, in essence, overriding the determination of the receiver with regard to the disposition of the assets. Is it statutory? Is it common law?
It's pursuant to the court's order.
So it's based entirely upon the order then, because as I read these cases, I did a lot of reading before I came out here. In the Fire Marshal versus Kircher case at page 535, it says, as an initial matter, we will not set aside a foreclosure sale in the absence of fraud, accident, mistake, or significant irregularities. Now, this isn't a straightforward foreclosure sale, I don't think, right?
It is not.
But it seems to me that that principle may have something